Hello, Tess. Good morning to all. Please kindly remember to put your phones on silent mode. Kindly remember to put your phones on silent mode. Thank you. In case you would like to use the earphones or interpretation equipment, English is 1, French is 2, Portuguese 3. English 1, French 2, Portuguese 3. Thank you. Ladies and gentlemen, shortly we shall start our opening ceremony. His Excellency is around. Kindly once again put your phones on silent mode. Thank you. Ladies and gentlemen, shall we rise? His Excellency the President. Kende. His Excellency Nana Akufo-Addo, President of the Republic of Ghana and Chairman of the Authority or Head of State and Government of ECOWAS. Your Lordship, the Chief Justice of the Republic of Ghana, His Excellency, the Minister of Foreign Affairs and Regional Integration, Chairperson, ECOWAS Council of Ministers, Honorable Attorney General and Minister of Justice, Honorable Ministers invited, Your Lordship, Judges of Supreme Court of Ghana, Honorable President, ECOWAS Court of Justice, the Vice President and Justice, ECOWAS Court of Justice, the ECOWAS Special Representative in Ghana, Commissioner, Commission of Human Rights and Administrative Justice, Deputy Commissioner, the President Ghana Bar Association, Ambassador, members of diplomatic corps, the Chief Registrar ECOWAS Corps, distinguished guests, directors from judicial services and ECOWAS Court, staff members, ladies and gentlemen of the press. By court order, on 29th day of October 2021, the President Community Court of Justice ECOWAS ordered that an external court session be held in Accra, Ghana, from Monday 21st March to 3rd April 2022. Anchored on Article 26(2) of the 91 Protocol of the Court, this provision is utilized over the years to bring closer the court to ECOWAS citizens. This year, Ghana Judiciary is hosting the court in Accra, and it is my pleasure to call on the Chief Justice to deliver his welcome address in the Temple of Justice. Chief Justice.
Your Excellency, the President of the Republic of Ghana and Chairman of the Authority of Heads of State and Government of ECOWAS, the representative of the Right Honorable Speaker of Parliament, my Lord Justices of the Judiciary of Ghana, the Honorable Minister for Foreign Affairs and Regional Integration and Chairperson, ECOWAS Council of Ministers, the Honorable Attorney General and Minister of Justice, the Commissioner of the Commission on Human Rights and Administrative Justice, the National President of the Ghana Bar Association and the Executives present, distinguished invited guests, our friends from the media, ladies and gentlemen, Your Excellencies, I am extremely glad to welcome you all to the opening of the external court session of the ECOWAS Court of Justice holding here in Accra for the next 2 weeks. I am happy to welcome in particular His Excellency Nana Addo Dankwa Akufo-Addo, the President of the Republic of Ghana and Chairman of the Authority of the Heads of State and Government of ECOWAS, who has taken time out of his busy schedule to be here with us this morning. May I also welcome warmly the delegation from the ECOWAS Court of Justice to Accra for the first time. Your Excellencies, we are indeed delighted that management of the ECOWAS Court of Justice has deemed it appropriate to move its court session to Accra, and for that matter, Ghana for the first time. This, I believe, is a step in the right direction, as it will foster a closer relationship between the court and the judiciary of Ghana. The holding of this session of the ECOWAS Court in Accra is great news, especially for aggrieved petitioners before it. It also creates greater awareness among the citizenry as members of the ECOWAS community. Your Excellencies, my Lord Justices, distinguished guests, as the current holders of the chairmanship of the Authority of Head of State and Government of ECOWAS and the ECOWAS Council of Ministers, the Republic of Ghana is indeed an important player in the affairs of the sub-region. As we all know, it is the duty of the ECOWAS Court of Justice as the principal legal organ of the body to facilitate the integration process of the community as regards treaty supervision and other oversight functions. In particular, the court is to ensure the observance of law and justice in the interpretation and application of the treaty, protocols and conventions annexed thereto, with the sole responsibility of settling disputes that may arise between member states and institutions of the community. In 2005, an amendment to the initial protocol on the court expanded this mandate from 2 to 4. Currently, thus the court acts as a community court, an administrative tribunal for ECOWAS community officials, a human rights court, and finally as an arbitration tribunal. We are happy to observe that the ECOWAS Court of Justice has indeed discharged its human rights mandate with distinction and has established a bold, authoritative, and globally acclaimed human rights mechanism. Let me use this opportunity to congratulate the court on the receipt of the Columbia Global Freedom of Expression Prize for 2022, which was recently conferred on it by the Columbia University. Your Excellencies, the mandates of the National Courts of Ghana are clearly spelled out in the Constitution of Ghana and in our national laws. While our national courts operate within our municipal system, the ECOWAS Court of Justice operates at our sub-regional level. The mandates of our two courts are clearly different, and as the ECOWAS Court of Justice has often maintained, we are not in competition. The ECOWAS Court is not an appellate court over the national courts of member states. There is, however, room for collaboration in the execution of our different mandates. The protocol on the ECOWAS Court of Justice has a provision on reference by national courts of member states to the ECOWAS Court of Justice on questions of the revised treaty, and also gives the national courts of member states the responsibility for the enforcement of the judgments of the ECOWAS Court of Justice. To this end, it is imperative that the Republic of Ghana domesticates the ECOWAS revised treaty and the protocols on the courts. It must also enact implementation legislation to enable the National Courts of Ghana to recognize and enforce the judgment of the courts. Furthermore, in view of the expansive mandate of the ECOWAS Court of Justice, it is necessary to review the decision that was taken in 2017 that reduced the number of judges of the court from 7 to 5. The court, I believe, requires an adequate number of judges to discharge its functions very effectively. Again, it would be necessary to review the 4 years non-renewable tenure of the members of the court to enable the community to derive maximum benefits from their wealth of experience. Your Excellencies, the external court session that the ECOWAS Court of Justice will be holding here for the next 2 weeks also offers members of the Ghanaian Bar the opportunity to observe an international court in session and to learn more about the practice and procedure of the courts. The judges of the National Courts of Ghana also has an opportunity to also know very deep into the fraternal relations with judges of the external court like this ECOWAS Court of Justice. Your Excellencies, permit me at this juncture to commend the capable leadership of the President of the ECOWAS Court of Justice, Honorable Justice Edward Amakwan-Santi, who I am proud to observe is a citizen of Ghana. We also wish to commend the colleague judges who, despite the reduction in their number from 7 to 5, have through the dint of hard work delivered 25 rulings and 114 judgments, thereby breaking many records in the annals of the court since the assumption of duty in August 2018. We are also assured that more judgments will be delivered by the court in the next 2 weeks during this external court session. I wish to assure the ECOWAS Court of Justice that we shall place at their disposal all necessary facilities to enable them achieve all the objectives of their mission here in Ghana. Your Excellencies, my lords, distinguished guests, ladies and gentlemen, may I conclude by expressing our profound appreciation to His Excellency, the President of the Republic of Ghana and the Chairman of the Authority of the Heads of State and Government of ECOWAS, Nana Addo Dankwa Akufo-Addo, for his consistently identifying with this constituency the legal profession as a whole. We are most grateful for your presence, Mr. President. Please permit me to once again warmly welcome the delegation of the ECOWAS Court of Justice and its supportive staff to Ghana and to wish them a pleasant stay in Accra. To all the dignitaries and invited guests here, do accept our thanks for honoring our invitation to attend this ceremony. I thank you for your kind attention. Long live Ghana and long live the community of states in the ECOWAS sub-region. Thank you.
Honorable Chief Justice, thank you for your welcome address. Our community is represented in each member state by a special representative or resident representative. It is the occasion for us to listen the first goodwill message from the ECOWAS special representative in Ghana. We have the floor.
Your Excellency, Nana Addo Dankwa Akufo-Addo, the President of the Republic and Commander-in-Chief of the Ghana Armed Forces and the Chair of the ECOWAS Authority of Heads of States, Your Lordship, the Chief Justice of the Republic of Ghana, Honorable Minister of Foreign Affairs and Regional Integration, and the Chair of ECOWAS Council of Ministers, the Honorable Attorney General and Minister of Justice of the Republic of Ghana, our Chief Justice of the ECOWAS Court of Justice, the President of the ECOWAS Community Court of Justice, Honorable Justice Edward Asante, the Vice President of the Community Court of Justice, and other judges of the Court of Justice of the community, members of the Diplomatic Corps, distinguished ladies and gentlemen. It is a privilege for me to join the distinguished audience gathered here this morning to witness another auspicious occasion which seeks to bring one of the three highest institutions of our regional organization to community citizens here in Ghana. the sitting of the court in Accra for the next 2 weeks for the first time will no doubt enhance the visibility of the entire regional organization and not just the Community Court of Justice. Following the innovations introduced by the 19th January 2005 supplementary protocol, as already mentioned by the Honorable Chief Justice, which provided direct access to the court for individuals and corporate bodies, the activities of the Community Court of Justice had increased tremendously. Subsequently, the court was able to take on board various issues of prime concern to community citizens, such as free movement of persons, goods and services, right of residence and establishment, as well as fight against gender-based inequalities and discriminations. Indeed, going through the series of annual reports issued by the court, there is no doubt that the Community Court of Justice had fulfilled the mandate it had assigned to itself and continues to do so, whether this resolves around the core judicial functions and administrative activities of the court or cooperation with other community institutions and international organizations. Over the years, in collaboration with other ECOWAS institutions and member states, the Community Court of Justice was able to embark on numerous study tours and training programs to build its own capacity and those of other stakeholders in line with global best practices. Various seminars and conferences had been held by the court on topical issues such as money laundering, financing of terrorism, the ECOWAS trade liberalization scheme, and a host of others. These engagements are extremely critical for the overall regional integration agenda of the community. Without such decisive interventions, it will be rather difficult to face the growing threats to the integration process in the ECOWAS region. By and large, the Community Court of Justice has also made noticeable efforts in embarking on new member states. At the same time, the court had also made remarkable efforts to ensure that cases before it are decided upon as fast as possible, in spite of the complexities involved in treating some of them. Perhaps I should also mention the fact that our development partners, particularly the European Union, had on several occasions commended the Community Court of Justice for its efforts in consolidating citizens' rights and promotion of other shared values. Equally important is to recall that the Honorable Justices of the Court have continued to interact with other regional institutions, parliaments, and non-governmental organizations beyond the West African sub-region. At this juncture, I wish to respectfully appeal to the Community Court of Justice to sustain the high tempo of activities it has demonstrated so far in pursuing the objectives it had set for itself, particularly in respect of enhancing the visibility of the court in the sub-region, strengthening cooperation with other relevant institutions, and remaining committed to capacity building in a rapidly changing world. I wish the Honorable Justices and staff of the court most fruitful deliberations in the coming days. Thank you for listening. Thank you.
Thank you, Ambassador Babagana Wakil. We acknowledge the presence of the Ghana Bar Association in our midst. It is my pleasure to call on the President Ghana Bar Association, Yao Boafwa, for his goodwill message.
Ceremony, and to stand before this illustrious gathering to deliver this goodwill message for and on behalf of the Ghana Bar Association, which I humbly lead as its current president, at this formal opening of the external session of the Community Court of Justice of the Economic Community of West Africa States, ECOWAS. We recall with fond and nostalgic memories the humble beginnings of the court, first created under the 1991 protocol, and the remarkable strides it has made in more recent times, especially following amendments introduced to its original protocol to the 2005 supplementary protocol of the court, which expanded its jurisdiction to cover and adjudicate cases relating to human rights violations committed within member states of ECOWAS. The decisions of the court, although deserving of celebration, are, however, without doubt, a vindication of and in tandem with the vision of the framers or founders to establish and maintain a regional court of justice, which will ensure the observance of law and equity in the implications of the ECOWAS Court of Justice. We deem it unacceptable for some member states to essentially decide as to which ruling or decision of the court they would comply with and enforce. It is important for me to state clearly that the judgments and rulings of the Community Court of Justice, just like all courts, ought to be obeyed and complied with, not only for its dignity and sustained authority of the court, but to ensure that public confidence in the judicial and justice system does not crumble, and that ECOWAS, as a sub-regional group, is taken seriously and commands respect from the international community, as well as to promote and ensure investor confidence within ECOWAS. The Ghana Bar Association, accordingly, entreats member states to work at putting the appropriate framework in place to respecting and enforcing judgments of the court as provided under Article 24 of the Supplementary Protocol, including designating appropriate authorities for the enforcement of the decisions of the court as stipulated in the Supplementary Protocol. At this juncture, please permit me to specially congratulate the President of the Court, an offspring of the Ghana Bar Association, and other distinguished justices of the court for the decision to hold this external court session in Ghana, a proud member of ECOWAS, pursuant to Article 26(2) of the Protocols of the Court. The reasons and incidents of such a decision cannot be far-fetched. For example, it ensures that delivery of justice is brought to the doorsteps of the citizenry, in whose name the court is currently established, pursuant to the provisions of Article 6 and 15 of the revised Treaty of ECOWAS. This is due to the obvious logistical, geographical, and financial constraints that citizens of member states may face in accessing the court located in Abuja, Nigeria. Thus, the importance of this external session of the court in Accra cannot be overemphasized. The instant session of the court in Ghana this year closely follows the reported successful session held at Abidjan, Côte d'Ivoire in October 2021. It is our fervent hope that this session in Ghana would even be more productive and serve as a benchmark for future external sessions of this regional court. In that regard, the Ghana Bar Association pledges its unflinching support to the court in delivering on its mandate of bringing justice to the good people of West Africa, especially during the present external session of the court in Accra. I therefore urge the learned men and women of the GBA to fully participate in this session, especially by offering pro bono service to the poor and vulnerable. Thank you very much for your kind attention, and God bless us all.
Our court, your court, is the human rights court of the sub-region. Kindly permit me to invite Mrs. Mercy Larry, Deputy Commissioner, Commission of Human Rights and Administrative Justice, Republic of Ghana, on behalf of the President, to take the floor.
Your Excellency Nana Addo Akufo-Addo, the President of Republic of Ghana and Chairman of Authority of State, Head of State of ECOWAS. Your Lordship, the Chief Justice of the Republic of Ghana, Your Excellency, President of the ECOWAS Commission, Your Excellency, Permanent Representative of ECOWAS to Ghana, Your Lordship, President of the ECOWAS Court of Justice, Honorable Attorney General, all other protocols are breached but duly observed for the sake of time. So, distinguished ladies and gentlemen, kindly pardon me for that. It is with much pleasure that I deliver this goodwill message to the Community Court of Justice, ECOWAS, on behalf of the Commission on Human Rights and Administrative Justice and the Commissioner, Mr. Joseph Whittal, who is not available in Accra due to circumstances beyond his control. The Commission has been following the good work of the ECOWAS Community Court with keen interest. Just 2 weeks ago, some staff of the Commission and some selected CSOs attended a 3-day workshop on litigation and engagement with Africa regional human rights treaty bodies organized by the Commission in collaboration with the Network of Africa National Human Rights Institution, NARI, in Accra, of which the Commissioner is the Vice Chair. Your Excellencies, I am glad to inform you that we learned so much about your court as it featured prominently in the curriculum of the consultant who took us through the various topics. The capacity building was also on how to assist in the implementation of ECOWAS Community Court and Africa human rights decisions at the national level, and human rights jurisprudence emanating from the ECOWAS Court to enable appropriate cases that CSOs and citizens, as well as the Commission itself, may decide to bring before the ECOWAS Court. Your presence and functions here in the next 10 days will add flesh and sinews to the theory we studied at the workshop. Your Excellencies, under the SDG 16A1, national governments are to strengthen national human rights institutions where they already exist in order to promote and protect human rights. We are happy to indicate that Government of Ghana has been faithful in this regard. Between 2016 to 2022, the staff strength of the Commission has increased from 670 to 1,080. The Commission currently has established offices in all the 16 regions and 148 district offices, up from 99 districts which existed previously. Also, the budget of the Commission has been seen remarkable increment over the period. We again wish to state that the intersectionality between the Ghanaian court and the Commission has equally witnessed some burgeoning understanding with regards to the enforcement of the decisions of the Commission in court. We nevertheless look forward to full appreciation of the practice direction of the Supreme Court at the lower courts. As a human rights institution, the Commission is excited that human rights mandate of ECOWAS Court has gradually become the mainstay of the court. We are also glad that through your vibrant ECOWAS human rights mechanisms, your court holds member states accountable for their treaty obligations to implement human rights under the international human rights instruments to which they are signatories. However, presently, a good number of human rights institutions in the sub-region are status B and not the enviable status A club which Ghana belongs. The Commission therefore humbly call on the head of states and government of ECOWAS through the chairperson of ECOWAS, His Excellency President Nana Akufo-Addo, to strengthen the legal framework of national human rights institutions in ECOWAS sub-region to meet the standards expected of them under the Paris Principles as strong partners of ECOWAS Community Court in the promotion and protection of human rights. We are looking forward to greater collaborations between the courts and the Commission in the protection and promotion of human rights of all persons in the sub-region. Missions such as this should continue to involve the Commission, as has been the case for some time now. The Commissioner himself sent his appreciation to you, Justice Edward Amoako-Asante, a contemporary and a friend, for making the judiciary of Ghana and the country proud by your election as the president to the august body. Your Excellencies, the Commission wish you and the entire court fruitful deliberations during this external court session in our beautiful and historic city of Accra. Thank you.
We would like to thank Mrs. Mercy Larbi for raising the alarm on standards of human rights in our sub-region. We kindly invite the Attorney General and Minister of Justice, Honorable Godfrey Yeboah Odame, for his statement.
Good morning. His Excellency the President of the Republic of Ghana and Chairman of the Authority of Affairs of State of Economic Community of West African States, Nana Dankwa Akufo-Addo, His Lordship the Chief Justice, Honorable Justice of the Supreme Court of Ghana, the President and Distinguished Justice of the Economic Community of West African State Community Court of Justice, the Honorable Minister for Foreign Affairs, and Chairman of the Council of Ministers of West African States, the President of ECOWAS Commission, President of the Ghana Bar Association, distinguished guests from various ECOWAS countries, ladies and gentlemen. May I first welcome the President of the ECOWAS Community Court of Justice, a son of our soil, His Lordship Justice Edward Amoako-Asante, and his distinguished brothers and sisters serving as justice of the Community Court of West African States to the beautiful city of Accra. Affectionately christened the Blaster of Africa, Ghana, previously known as the Gold Coast, became the first tropical country, both in Africa and the Caribbean, in modern times regained independence from colonial rule and domination. Under the leadership of our first president, Kwame Nkrumah, of whom a leading historian once described as the star of Africa's destiny, the nation lit up a torch of inspiration for the rest of the world, still fighting for their own independence. Ever since, we have been the beacon of the quest for self-government, democracy, good governance, and generally the rule of law in Africa. The status of our president, Nana Dankwa Akufo-Addo, as the chairman of the Economic Community of West African States, and the giant efforts made by him in ensuring that Ghana preserves her identity as a haven for peace, stability, democracy, and good governance, in spite of the disturbing wind of coup d'etats blowing around the West African sub-region, highlights the point that the Community Court of Justice could not have chosen a more appropriate venue for its external sittings. You are indeed home, and I extend to you a warm akwaba, as we say it over here. My Lord Justice, I hope that you, over the course of your stay, and upon the conclusion of each day's sitting, find time to enjoy the dynamics of the fascinating and riveting socio-cultural life of our vibrant city as well. There are many places of entertainment which, if you see me in chambers, I will disclose to you. Mr. President, this external session of the ECOWAS Community Court, the 11th of its kind, being held pursuant to Article 26, Clause 2 of the ECOWAS Protocol, establishing the court has value in bringing the operations of the court to the doorstep of the ECOWAS citizen. Essentially, it is an outreach exercise for the court and delivers an opportunity for the ordinary member of ECOWAS state, and indeed lawyers and judges, to familiarize themselves with the operations of the ECOWAS Community Court, its competence, mandate, practice, and procedure. Affording an opportunity for the justices of the court to interact with senior political authorities of host member states, it portends the ability to deepen the relations between the community court and member states, with the ultimate result of encouraging obedience to decisions of the court. May I, at this point, and I think it's very apt, say a hearty congratulations to the ECOWAS Court of Justice for winning the Global Freedom of Expression Prize in 2022, awarded by the Columbia University. The prize is primarily an account of the court's landmark ruling in Amnesty International versus the Republic of Togo, in which the court held that access to the internet is a derivative right and requires the protection of the law, and therefore the shutting down of the internet by the government of Togo during demonstrations by its citizens considered an interference with the right to freedom of expression. Indeed, it is correct to say that this court is rapidly carving a solid niche for itself in the protection of rights. We congratulate you. Mr. President, the jurisdiction of the ECOWAS Court of Justice originally fashioned the court out as an engine for integration, as Article 9 of the 1991 ECOWAS Protocol, which established the court, charged the court to, and I quote, ensure the observance of law and the principles of equity in the interpretation and application of the provisions of the treaty. In this regard, the court was required to adjudicate disputes relating to the integration project contained in the ECOWAS Treaty, reduce trade barriers, harmonize national economic and financial policies, and build a common market and monetary union. By a 2005 supplementary protocol, which codified an earlier decision of the court in which it construed its original jurisdiction under Article 9 of the 1991 protocol to cover human rights cases, the jurisdiction of the court was significantly expanded, with the consequence that the court can now assess jurisdiction over 4 general types of disputes. And this has been amply set out in the speech of His Lordship the Chief Justice. Whilst commending the expansion of the jurisdiction of the ECOWAS Court, a rather downside to this development is that the future of the court as an instrument for integration across the ECOWAS community remains in doubt due to the fact that dockets of the court contain few cases, if at all, involving tariffs, trade barriers, and other integration law issues. Instead, they are dominated by suits by individuals and non-governmental organizations alleging human rights violations. There ought to be a strategy for boosting the number of cases invoking the court's jurisdiction on account of migratory issues, non-tariff and other unfair trade measures adopted by countries in the West African community, as part of a broader strategy to enhance the court's originally conceived role as an engine for integration. Mr. President, I note that both the 1991 protocol and the 2005 supplementary protocol omitted the requirement to exhaust domestic remedies before invoking the jurisdiction of the ECOWAS Court. This is a marked departure from the practice and procedure adopted by other international judicial and quasi-judicial human rights bodies, to the extent that exhaustion of local remedies is a foundational element of the 3 major regional courts around the world: the European Court of Human Rights sitting in Strasbourg, the Inter-American Court of Human Rights in San Jose, Costa Rica, and the African Court of Human Rights based in Arusha, as well as the various UN treaty bodies. The omission of this requirement from the protocol establishing the court, in my humble view, poses a grave danger to the survival of the court, as it brings the court into potential political conflict with domestic courts of member states. The omission of a requirement to exhaust local remedies is also responsible for the ever-recurring difficulties in securing enforcement of decisions emanating from the ECOWAS Community Court of Justice. Legitimate questions about the sovereignty of nations and the supremacy of a republic's constitution are raised when a citizen of one country sidesteps all the avenues for resolution of a dispute available under the constitution of his own country and directly accesses the ECOWAS Community Court. Respectfully, I find this design feature of the ECOWAS Court quite curious, as ECOWAS states have been reluctant to grant similar authority to the judicial authority of the African Charter on Human and People's Rights, for instance. In my view, there is no justification for member states with strong human rights record and formidable judicial institutions like the Republic of Ghana to be denied the opportunity to redress an alleged wrong within the framework of its own domestic legal system before international responsibility may be called into question. The time has come for an amendment of the protocols establishing the ECOWAS Court to incorporate a requirement for exhaustion of domestic remedies as a precondition for access to the court. And I say this on authority because the chairman of ECOWAS himself is present with us this morning. I already say, if you have any message to the Lord Almighty, speak to the wind. An execution of this proposed amendment will realign the practices of the court with prevailing customary international law and various international treaties supporting litigation before international court. Legitimately, ECOWAS may adopt certain exceptions to the necessity for an exhaustion for domestic remedies. These exceptions may be: 1, where there is the absence of such domestic remedy, or same can clearly be shown to be ineffective. 2, where the procedure is demonstrably unfair and can be shown to involve undue delays. And 3, where the available remedy cannot adequately redress the alleged violation. As an alternative to the requirement to exhaust domestic remedies, that is, if the authority of heads of state are opposed, I will propose the establishment of an appellate division for the community court, i.e. another layer for subjecting decisions of the court to scrutiny. In addition to providing assurance against any serious or grave errors in rulings, the creation of an appellate chamber will eliminate the perception of the court being the be-all and end-all in matters over which it is clothed with jurisdiction. Respectfully, whilst alluding to these few flaws I observe with the constituent instrument of the court, I urge all member states to support the work of the court through the institution of a credible procedure for enforcing decisions emanating from the court in their respective countries. By the combined effect of Article 22(3) of the protocol and Article 24(2) and 3 of the supplementary protocol, this ought to be done by the enactment and dissemination of some legislative and statutory tests as are required for execution of judgment in order not to render decisions of the court nugatory. In this regard, I'm proud to say that Ghana has conducted itself commendably. We have not fallen foul of the community law. In one rare instance, when the court awarded judgment in the sum of about $500,000 against her recently, we complied and satisfied him. Mr. President, I wish the Honorable Justice of the Community Court of Justice a successful session in Ghana, and I look forward to seeing you at the reception to be organized by me on Wednesday. Thank you very much.
Chairperson of ECOWAS Council of Ministers, and always the first ear of our respected head of state, I invite Honorable Shirley Ayoko Bochwe, Minister of Foreign Affairs and Regional Integration, to take the floor.
Your Excellency Nana Addo Dankwa Akufo-Addo, President of the Republic of Ghana and Chair of the Authority of Heads of State and Government of ECOWAS. Representative of the Right Honorable Speaker of Parliament, Your Lordship, the Chief Justice of the Republic of Ghana, Honorable Minister for Justice and Attorney General, Your Excellency, President of the ECOWAS Court of Justice, Your Lordships and Ladyships, Representative of the Commissioner for Human Rights and Administrative Justice, the Chief Registrar of the ECOWAS Court of Justice, the Permanent Representative of ECOWAS to the Republic of Ghana, President of the Ghana Bar Association, the media, distinguished ladies and gentlemen. I deem it a great privilege to be invited by the leadership of this august House to the opening ceremony of the External Court Session of the ECOWAS Court of Justice. The External Court Session has been an annual work program of the ECOWAS Court of Justice aimed at bringing justice to the people at the grassroots of the community, especially those who are unable to bear the cost of traveling to the seat of the court in Abuja in the Republic of Nigeria to access justice. The ECOWAS Court of Justice, as part of the mandate of the ECOWAS in promoting economic integration across the region, has the jurisdiction to examine cases involving alleged failures by member states to comply with community laws, disputes relating to the interpretation and application of community acts, disputes between community institutions and their officials, community liability, human rights violations, and the legality of community laws and policies. I believe these external court sessions of the ECOWAS Court of Justice are intended to urge member states to respect the governing instruments and policies of ECOWAS, as well as provide an opportunity for citizens to observe the court in session, sensitize the public, and engage with its stakeholders. As Africans, we are challenged to renew our commitment to the same tenets of unity and solidarity that moved our forebears to light the torch of independence over the subjugation of colonialism. We must continue to respect and tolerate different views, opinions, cultures, races, genders, and languages. It is through the appreciation of such differences that we can live peacefully with each other and fulfill our aspirations as a regional body towards the realization of the flagship project and aspirations outlined in Agenda 2063, the Africa we want. Distinguished ladies and gentlemen, it is worth noting that the court received several requests to hold an external court session in Accra, Ghana, considering the pending cases requiring oral hearings and examinations of applicants and witnesses who cannot bear the cost of traveling to Abuja from Ghana and other neighboring member states, hence the holding of this court session to address these issues. I would also like to commend the ECOWAS Court of Justice for its evident progress in deploying technology towards reaching out to member states, especially during the COVID-19 period. As chair of the authority and as chair of the ECOWAS, Ghana continues to take a very active interest in the affairs of the region as a whole and has made strenuous efforts to deliver on its mandate of promoting peace, stability, and regional integration among and within member states, with the aim of contributing to the realization of the overall objectives of ECOWAS. Excellencies, distinguished ladies and gentlemen, to conclude, I urge the ECOWAS Court of Justice to continue to project and deliver on its mandate as an organ with enshrined democratic credentials in furtherance of the principles of democracy and good governance, and in line with the tenets of ECOWAS. It is also expected of us member states, therefore, to lend our full support to the work of this House in harnessing its potential in dealing with the recent reversals in the adherence to democratic principles in our region. At the same time, let us resolve to reinforce African solidarity, unity in diversity, and bring that to bear on our reflections concerning the challenges confronting our region. Thank you for your attention.
Merci, Excellence Madame le Ministre, pour vos mots d'encouragement à l'endroit de la Cour de justice de la CEDEAO. Elected by his peers at the inception of their tenure, he is the President, Community Court of Justice, ECOWAS. Let us welcome His Lordship Justice Edward Amwako Asante, President, Community Court of Justice, for his statement.
Your Excellency, the President of the Republic of Ghana, Honorable Chief Justice, may I be permitted to rely on the already set up protocol. Your Excellencies, my lords, ladies and gentlemen, I'm greatly delighted to have the rare opportunity to welcome, on behalf of the ECOWAS Court of Justice, His Excellency Nana Addo Dankwa Akufo-Addo, President of the Republic of Ghana and Chairman of the Authority of Heads of States and Government, ECOWAS, to the opening ceremony of our 2 weeks external court session here in Accra, in the Republic of Ghana. We are very honored that His Excellency could spare time from his very busy schedule to be with us at this event. May I therefore avail myself the opportunity to express on behalf of the honorable judges and the court our profound appreciation to His Excellency for his kind gesture, and to the government and people of the Republic of Ghana for the warm reception that has been accorded the delegation of the court since our arrival in Accra. It is indeed a great honor for the delegation of the court to be warmly received on the Ghanaian soil, and we are delighted for that. Your Excellencies, may I also seize the opportunity to express our great appreciation to the political and judicial authorities of Ghana here present, especially the Chief Justice, the Honorable Minister of Foreign Affairs, the Attorney General, Chairperson of Council of Ministers, the Attorney General, for availing us the opportunity to conduct the external court session here in Accra, and for the African brotherly hospitality since we arrived in Accra. Your Excellencies, please permit me to express my profound gratitude to the Chief Justice for the excellency facilities he has placed at our disposal in this beautiful court complex to enable us complete our duty here. The presence here at the opening ceremony of this external court session of His Excellency the President and key members of the political and judicial members, a clear demonstration of their respect for human rights and their show of respect for consideration for the Community Court of Justice. May we also assure you all that our presence here is also a recognition of the leading role of the Republic of Ghana the Republic of Ghana is playing in the integration process in ECOWAS, and our desire to deepen collaboration between our court and the national courts of the member states. Your Excellencies, the external court session is a very useful tool for us to create awareness about the court, its mandate, jurisdiction, practice, and procedure. Since ECOWAS, in its Vision 2020, evolved from an ECOWAS of states to ECOWAS of peoples, it is expedient that the people, that's the community citizens, should know the Community Court of Justice, which is their court, and therefore take ownership of it. The external court session also offers the court the opportunity to deepen the relationship between it and the national courts of member states. Since the court commenced the external court program in 2007, it has been successfully carried out in Niger, Mali, Benin in Nigeria, Togo, Guinea-Bissau, and twice in Côte d'Ivoire, and now in Ghana. It is our hope that this session in Accra will also be very successful. Your Excellencies, I wish to strongly emphasize that the ECOWAS Court of Justice is not an appellate court over the national courts of member states, as already said by the Chief Justice. Although we exercise concurrent jurisdiction with the national courts in respect of human rights, we only entertain complaints of human rights violations that pertain to the international and community obligations of member states under the international human rights instruments that have been signed by those member states. Therefore, we are only concerned with applications against member states in respect of their treaty obligations with respect to protect, and fulfill human rights obligations within their territories. We are therefore not in competition with the national courts of member states. Your Excellencies, my lords, distinguished guests, ladies and gentlemen, may it be noted that the human rights mandate of the court is very unique because there is no requirement for exhaustion of local remedies which the Attorney General is opposed to. Although human rights protection is the centerpiece of our judicial caseload, we are mindful of the fact that the court was set up to facilitate the economic integration process of the community. However, in order to carry out this function effectively, we need a collaboration of our national courts of member states that have the obligation to enforce the judgments of the court In order to maintain uniformity in the interpretation of the treaty and other ECOWAS legal text, our protocol has also given an exclusive jurisdiction in respect of interpretation of its text. It therefore empowers the national courts to make referrals to our courts on questions of the treaty in matters before them. I regret, however, to say that no such referral has ever been made from any national court. May I also point out that we have challenges regarding the enforcement of the judgments of our court by the national courts, arising mainly from the fact that member states are yet to domesticate the ECOWAS revised treaty and the protocols on the court. The lack of implementation of this legislation that will empower national courts to recognize and enforce judgments of our court is also a militating factor. Currently, member states comply with our judgments at will and at their own convenience. This places the enforcement rate of our judgments at about 30%, which is very sad. We are deeply concerned about this state of affairs and will continue to appeal to all member states to do the needful. Your Excellencies, during this court session here in Accra, we will hear 60 cases and deliver 25 judgments. You may wish to note that most of these cases emanate from Ghana and neighboring states and involve alleged violations of human rights. It is also a hybrid session in which parties, their lawyers and agents may choose to participate either physically or remotely. It is our hope that by hearing these cases on Ghanaian soil, it will assure the Ghanaian nationals and other persons in the territory of Ghana of the availability of the regional justice in protection of human rights in case of breach of any of their human rights by the states. Your Excellencies, my lords, distinguished guests, ladies and gentlemen, permit me in conclusion to once more express our deep gratitude of the ECOWAS Court of Justice to His Excellency the President for honoring us with your presence at this event. May I assure you that we will continually extend our hand of fellowship and solidarity to the government and the good people of Ghana. As a court, it belongs to the member states, and we remain committed to the ECOWAS integration. It is our hope that in the years ahead, the fraternal relations between the court and the government and the good people of Ghana will continue to flourish. I thank you for your attention. Merci beaucoup pour votre aimable attention. Muito obrigado.
Et nous allons continuer en disant qu'il est un champion de la cause des droits de l'homme. De par sa profession d'avocat, jusqu'à l'entrée au palais de la République, il n'a ménagé aucun effort pour que les droits de l'homme soient respectés. C'est un plaisir, un réel plaisir d'inviter Son Excellence, Monsieur le Président de la République, à prendre la parole pour ouvrir solennellement la session de la Cour de justice de la CEDEAO en République du Ghana. J'invite Monsieur le Président de la République.
Chief Justice, President and members of the ECOWAS Court of Justice, Ghana's Minister for Foreign Affairs and Regional Integration, and Chairperson of the ECOWAS Council of Ministers, the Attorney General, Justices of the Supreme Court, and other Justices of the Superior Court of Judicature, Deputy Attorney Generals, Judges, members of the Judicial Council, the President and members of the Bar Council of the Ghana Bar Association, Judicial Secretary, members of the Diplomatic Corps, fellow West Africans, ladies and gentlemen. I'm delighted to be in the midst of judges and distinguished guests at the opening ceremony of the external court session of the ECOWAS Court of Justice, which is being held in Accra, the vibrant capital of Ghana, a city with a well-deserved reputation for its warmth and hospitality. Akwaba is our word of welcome to those of you who come from beyond our shores, and I hope you enjoy your stay with us, although brief. It is good to welcome the President of the Court, the Honorable Justice Edward Amwako Asante, back home, if only for a few days. I commend the management of the Court for holding the 2022 External Court Session of the Court here in Accra. This is the second time an event of the ECOWAS Court of Justice is being held in Ghana under my presidency, and for which I'm grateful. This morning's event, I'm told, is a key activity in the annual work program of the court. And I received the assurance of Ghana's Chief Justice, Justice Kwesi Enin-Yeboah, that the requisite facilities in this law court building have been placed at the disposal of the delegation from the ECOWAS Court of Justice to enable it to accomplish its mission. Article 26.2 of the Protocol on the Court empowers the court to leave its base in Abuja to sit in the territory of any other member state where the facts and circumstances of a case so warrants. By coming to Accra, the court is giving Ghanaians the opportunity to observe the court in session and to learn about its practices and procedures. In addition to the legal significance of the external court session, it also serves as an outreach program to sensitize community citizens about the workings of the court. On behalf of the Authority of Heads of State and Government of ECOWAS, of which I have the honor to be its current chair, and as President of the Republic of Ghana, I commend the court for the work it is doing in the discharge of its various mandates, particularly its human rights mandate. I also congratulate the court for the recent award it has received, the Columbia Global Freedom of Expression Prize for 2022. This is indeed laudable, and we're all proud of the court for this achievement. Ladies and gentlemen, in Ghana's constitutional democracy, we place a very high premium on our court system and on the rule of law. The judiciary is a crucial arm of government, as there cannot be the rule of law without a strong independent judicial system. For us in Ghana, the Constitution of the Republic has decreed that the judiciary has the final say in all matters of the breach of the law, civil and criminal, including the exclusive jurisdiction to interpret and enforce the basic law of the land itself. The Constitution has conferred onerous responsibilities on the judiciary to protect the individual liberties and fundamental human rights of citizens, to act as the arbiter in disputes between the state and the citizen, and to act as this arbiter in disputes between citizens, and to serve as the bulwark for the promotion of the orderly development of our nation and for the defense of the liberties and the rights of our people. The ECOWAS Court of Justice, as the guarantor of our ECOWAS community norms, must ensure the observance of law and justice in the interpretation and application of the ECOWAS revised treaty, protocols, conventions, and supplementary acts of our community, and in settling disputes that arise between member states inter se or between institutions of the community arising from ECOWAS legal texts. It goes without saying that the court has a strategic role to play in the integration process of ECOWAS. In addition to its contentious and advisory jurisdictions is clearly spelled out in the protocol on the court. The authority of heads of state and government is empowered under Article 9(7) of the protocol of the court as amended to grant the court the power to adjudicate on any specific dispute that it may refer to the court other than those specified in the protocol. The court must thus be ready at all times to assume additional responsibilities. I'm, however, aware of the concerns of many stakeholders regarding the reduction of the number of judges of the court from 7, as provided for in its initial protocol, to the current number of 5. I believe that it will be appropriate to have a second look at the decision in order to review the merits of restoring the composition of the court to 7 members. It is in the interest of our community that the court is strengthened to provide the enabling legal environment for the integration of our region. We must refocus the judicial mandates of the court on the integration process. Although ECOWAS has recorded a lot of achievements since its establishment in 1975, the time for us to focus on the establishment of a community legal order and the harmonization of the legal and judicial systems of the member states. National sovereignties should not be an impediment to the realization of our community objectives. All that is needed is the necessary political will. Despite the best efforts of the ECOWAS Court of Justice to deliver on its mandates, it is constrained by the poor rate of enforcement of its judgments, which presently stands at some 13%. Unless member states comply with the judgments of the court, it will be difficult to build public confidence in the court. I appeal to all member states to ensure that they comply with their treaty obligations by observing and obeying the judgments of the court. All member states that are yet to appoint their competent national authorities for the enforcement of the judgments of the court are respectfully urged to do so without further delay. Ghana, on her part, has designated the Office of the Attorney General as her national authority. Ladies and gentlemen, we note with regret the insecurity and terrorist activities in many parts of our region, which remain sources of grave concern. We're equally dismayed by the unconstitutional overthrow of democratic governments in 3 of the member states of ECOWAS, Mali, Guinea, and Burkina Faso. The ECOWAS Protocol on Democracy and Good Governance, under its constitutional governance principles, provides that, and I quote, "Every accession to power must be made through free, fair, and transparent elections." Unquote. It also provides, quote, "zero tolerance for power obtained or maintained by unconstitutional means," unquote. The authority of heads of state and government of ECOWAS has followed its long-established tradition by suspending the 3 member states from participation in the activities of ECOWAS and imposing the necessary sanctions. We shall continue our untiring efforts to re-establish democratic governance in the suspended member states as soon as possible. Our court systems, both at the municipal and regional levels, have crucial roles to play in the maintenance of peace and stability in our region. Participatory democracy, rule of law, good governance and respect for human rights are essential factors for sustainable development for our region. Thus, The people must necessarily participate in governance. Elections must be free, fair, and transparent. The independence of the judiciary must be guaranteed. Judges must be independent in the discharge of their duties. Before I conclude, there is a matter of considerable importance and growing significance I want to bring to your attention. The original jurisdiction of the ECOWAS Court, as stipulated in Article 9 of the Protocol establishing the ECOWAS Court, confined the Court's jurisdiction to the interpretation and application of the provisions of the ECOWAS Treaty, the resolution of disputes between member states, and the resolution of disputes between one or more member states and an institution of ECOWAS on the interpretation or application of the provisions of the treaty. This jurisdiction conferred on the ECOWAS Court was consistent with the jurisdiction conferred on similar courts, such as the East African Court of Justice and the Court of Justice of the European Union, by their enabling statutes. The ECOWAS Court has been further clothed with the power to act as arbitrator in matters until the arbitration tribunal provided for under Article 16 of the ECOWAS Treaty is established. It has also been provided with jurisdiction over allegations of human rights abuses in member states. This expanded jurisdiction does not require parties to have exhausted all local remedies prior to invoking the jurisdiction of the court, and in some cases results in judgments that member states find difficult to enforce or are inconsistent with the concerned member states' municipal laws. Some judgments have even led to efforts to attach state assets in satisfaction of the judges. However, this is not the practice in other international courts. For example, in an application to the African Court on Human and People's Rights, an applicant must demonstrate that all local remedies have been exhausted or obviously unduly prolonged. Otherwise, the application will not be admitted. Again, the admissibility criteria for an application to the European Court of Human Rights requires that all domestic remedies should have been exhausted in accordance with generally recognized rules of international law before the European Court of Human Rights will deal with the matter. I will, in these circumstances, make a suggestion for the respectful consideration of the court, which in my view would obviate any potential conflict between the court and national governments and allow for the systematic development of the court's authority. And that is, without recourse to a formal revision of the guiding protocol, to impose a rule of judicial self-restraint that would insist that an applicant for the exercise of the court's expanded jurisdiction satisfy the requirement of the exhaustion of domestic remedies prior to the successful invocation of the court's jurisdiction. Such a rule, even if judge-made, like practice directions in common law judicial jurisdictions, would align the practice and procedure of the court in the exercise of its expanded jurisdiction with the equivalent jurisdiction of similar courts in the international sphere. And I'm happy to see that on this matter too, my Attorney General and I are of the same opinion. My presence here at this ceremony underscores the importance of the judiciary as a crucial arm of government. It also recognizes the special role of the ECOWAS Court of Justice in the integration process of our community and the tremendous work it has done in respect of its human rights mandate. It is my hope, and the hope of all believers in the rule of law, that the court will continue to grow from strength to strength. Accordingly, ladies and gentlemen, I declare the 2022 External Court Session of the ECOWAS Court of Justice in Accra duly open. I wish you fruitful sitting in Accra. May God bless the peoples of ECOWAS and us all. And I thank you for your attention. Je vous remercie vivement pour votre aimable attention. Muito obrigado. Thank you.
A strong round of applause, please. Following the anthems, we'll have 3 groups of pictures. The first will be His Excellency with the Community Court of Justice judges. Second one, His Excellency, the Chief Justice of Ghana and judges of ECOWAS Court and the Chief Registrar. And the last one, which is the President, the Chief Justice, the Minister of Foreign Affairs, the Attorney General, Honorary Judges of Supreme Court, and Justice of the ECOWAS Court and the Chief Registrar. With the permission of His Excellency, we would like to call on the ECOWAS anthem and Ghana anthem first, and then after the good preacher. His Excellency and the 5 judges of the ECOWAS Court, please. Photographers, you have 10 seconds, please. Kindly remove your mask for recognition on the picture. Honorable Chief Justice of Ghana, you are called on, please. And Chief Registrar, ECOWAS Court. We kindly invite the Chairperson, Council of Ministers, Attorney General, Honorable Justices of the Supreme Court to join. Kindly remain seated until the departure of His Excellency. Thank you very much. Kindly remain seated for some informations, please. Thank you. Honorable Chief Justice and the judges of ECOWAS Court are awaited in Chief Justice's office for the refreshment. The Chief Justice and the ECOWAS judges in the Chief Justice's office. Chief Supreme Court judges, ECOWAS guests, ECOWAS directors, ambassadors to the